Hello. I'm very happy to be here and have the opportunity to make available to you my experience in practical patent law that I gained through 3 years working as an examiner in the German Patent Office and some 30 years working as a patent examiner in the European Patent Office. In 1996, I spent 3 months as technical expert in the Malaysian Patent Office. In 1998, 1 month in Mexican Patent Office. I would be very happy to contribute the idea of establishing law, treating patent law, which surely will be a process in the time to come. Of course, all what I say is only my personal opinion and has nothing to do with the official position of the European Patent Office or the German Patent Office. So, Mark Twain said, the secret of getting ahead is getting started. I was invited as a senior expert to come to Jakarta. What is an expert? Well, an expert is someone who learns more and more about less and less. So, you are now experts in learning a lot about patents, hopefully. You will become experts. Now, the first slide. Who am I? I'm not a Bavarian. On the right side, you see a picture of a Bavarian. I live in Munich. That's Bavaria. I was born in Westphalia, that's some 700 kilometers in the north of Munich, but I live in Munich for the last 35 years. Yes, you see, I studied organic chemistry. I'm a chemist in the north of Germany, and then I accompanied my professor to Freiburg, that's in southern Germany. I was then working as a scientific assistant in radiation biology at the University in Münster. Then I joined the German Patent Office for 3 years, and then on April 1986, I joined the European Patent Office. And there I was a tutor for more than 40 colleagues, and then I became a best tutor in The Hague. Now you would ask, what is a best tutor? Of course, the best. But the idea was, in the beginning of the European Patent Office, it was decided to separate search and examination. There were search examiners working in The Hague, and examination was done in Munich. The idea behind that was to improve quality, and this works as long as both parties know exactly what the other party needs. But after a couple of years, it turned out that this was not the case, in particular as far as inventive step is concerned. So the office decided to do BEST, bringing examination and search together, BEST. Everybody was invited, every examiner in the European Patent Office was invited to do BEST, and I became the best tutor in The Hague, trying to learn to teach examiners examination who until that time only were doing search. In the German office, I learned both. When I started in the German office, I did search and examination at the same time. As I told you, that was different in the European Patent Office in the beginning, but it changed. Today, we only have best examiners. Now, just let me say a word about questions. There are no silly questions. If you have any problem, ask. There is the problem is that what I say is based on my personal education information, and it may be that for you it's a bit different. So please ask. Now, a bit of the history before we go to the patent. The patent exclusive right for a limited period of time. The first idea of giving and taking is, in the sense of a monopoly, already can be found some 700 years before Christ, BC. And it was in ancient Greece, 500 BC, and then in the Middle Ages, no, just one back. I want to say something about the history very shortly, but it's interesting that this idea of giving and taking in the sense of monopoly is very old. It was, as I said, in ancient Greece, then in Italy, patent letters were given for the transport of marbles. So the idea existed. Then in England, there were letters by the kings instructing a new industry, letters patent, provided there is with a monopoly to produce particular goods or provide particular services. The first Italian patent was in the Republic of Venice, and then so on. But the patent system as such only began when the industrialization began, England, Germany, France. And then a very interesting story, there's one President of the United States who was a patentee, Abraham Lincoln. And this patent that he got from the American Patent Office concerns a system for boats. He stuck in the sand when he crossed rivers, and he was very annoyed about that. So he had the idea of constructing certain devices to put on the boat to put pressure in it so the boat could be moved and was not stuck on the sand. That's his patent. He was a patent attorney before he became president. He was very well acquainted with the process of patenting. So and I think one very interesting, if you could, one of his sentences is, I think for today, for us, very important. The patent system adds the fuel of interest to the fire of genius. So 1849, I think this sentence, we should take it very much into our world of today. Okay, now but let's go into the real world of patents. Perhaps one idea before. There's a big discussion about the relationship between quality and quantity in various technical fields, in patent law, also in normal law. And I think there's a good definition. The quality of a patent is the extent to which a patent system corresponds to the legal status in a transparent manner. So my personal opinion is that the patent system has to be oriented to maintain several important parameters. And as I'm going to show you later, the most crucial and very important parameter of patent law is inventive step. Now, why is that? Let me say a few words about that. We will see later why this is the case. Inventive step is important because the level of inventive step has a big influence on this patent system as such. If the level of inventive step, if you have a low level inventive step, you make it very easy to the so-called patent trolls to enter the patent system. And what is a patent troll? I found definition in the internet to be very neutral. A patent troll is disparaging term for a person or company that hoards patents for the purpose of threatening alleged infringers with legal action. Usually the patent troll holds patents that are vague and ambiguous and seeks to enforce patent rights extending beyond the patent's actual value or contribution to the prior art. So if you have a low-level patent, it is easy for these patent trolls to get a patent and then to annoy big companies. And I found a number in the internet. In the first 3 quarters of 2022, 64% of all patent lawsuits were filed by patent trolls. So you see, this is an important question and it depends upon the level of inventive step. The second point is that the lower inventive step is, the more patents applications you will have. And then there will be patents granted which do not correspond to the question of innovation, because a patent is only justified, this monopoly for a limited time, if it contributes to innovation. But if you have these low-level patents, depending upon low-level inventive step, then these patents cost a lot of money, and there is no contribution to innovation. So this is also a good reason why a reasonable level of inventive step should be maintained. But you will see later why. So now that's really patents. Well, everybody who treats patents knows patents are granted for novel and inventive subject matter, which is industrially applicable. Industrially applicable, that's in 99% no problem, because if you pay money, then you want to sell a product. There are some minor exceptions, moral, ethic aspects. There was a long discussion, I remember, in the European Patent Office, whether the cocktails given to prisoners for penalty death should be patented or not. It was decided to do that, but okay, that's one of these questions where you can discuss industrial applicability. Now, these 3 criteria, I put down the European patent system. Then in the Indonesian Patent Act, you see there's also these 3 criteria, and in the German Patent Act as well, novelty, inventive step, and industrial applicability. That's the three conditions under which a patent can be granted. Now, you see the Indonesian Patent Act. A patent as referred to new invention, involvement, and susceptible to industrial application. So actually there is, in all patent acts, this is quite similar. The wording is a bit different, but in the end it's the same: novelty, inventive step, and industrial applicability. Now, the next slide, please. What can we do to understand patents? Now let's imagine what I'm referring now to is my idea to make these conditions for granting a patent visible. Now you see graphics. To the left you see a big M. This big M means this is all the technical, structural, functional features which are known. And if you want to make a patent, if you want to grant a patent, this must be novel. So to the right you see there is all the technical, structural, functional features are there. But what has been changed is F1 to F2. So there is graphically put down a novelty rendering feature. You will see within a couple of minutes what I mean. I put it already there. Novelty in 90 to 99% of the cases will be in the patent a replacement, an addition, deletion, or a selection overlap. That's actually in many cases responsible for novelty. And you see, you can make novelty graphically visible. Whatever this M can be, a button, a machine, a process, any patent you can imagine. You have a certain background which is put in M, and you must, if a patent can only be granted if it's novel, so there must be a novelty rendering technical, structural, functional feature. That's the first slide, and then you easily would think, but what about improvements? Many patents refer to unprecedented the effect should be, the activity should be improved qualitatively, quantitatively. So there's a second possibility for patents, and this is graphically put down here. You have the novelty rendering technical feature, F1, F2, and you have the changes in the activity. Activity, effect, result, property, purpose, function. I put in M the preamble. We have I don't know, I didn't look into the Indonesian patent law. In the European system, you can put a preamble, a two-part form of claims. What is known in the prior art, that's the preamble, and then you continue with what is novelty, what is novel, the technical features which add something to the prior art. So this M would be a representative for the preamble, if that exists. So that's the two possibilities to present, to put down graphically novelty. This is applicable to anything you want to invent. You have to start with something which is known, and you make it novel by this novelty running technical feature. The first slide I showed you, that's if you want to provide something alternative or additional. And then the second slide, that's if you want to provide subject matter with modified, unpredictable activities, quality, quantity. So all this, there are a lot of possibilities. But that's essentially the most important reasons for novelty. So with these two, you have a model for novelty, a graphical model in your head for novelty. So next slide would be, you can go through, if you can, that's another possibility to show that's a replacement. So you have replaced F1 by F2. Next one, please. There you have an addition, you have added something. It's just the same what I showed before, but in a different manner. So you have a deletion, something is there in the prior art, but is missing in your patent. And then you have the selection and overlap. Yeah, I want to say a word about selection and overlap. That's something which is really patent language. When I explained that to my colleagues in the laboratory, they said, no, that's not novel. Because, but in the patent system, we have the possibility of selecting something. So, for example, if in a patent it is said you use a metal for that and that, produce a device or a process. And then and there's a list of all the metals which can be used, copper and manganese, cobalt. And then someone works in this field and he finds out that for specific metals, copper or manganese, there is a specific effect. Then he can claim this as a selection. This is novel in the sense of a patent. For a scientist, it's not novel, but for a patent examiner and for patent attorneys, it's novel. The same is the famous overlap. You have overlapping, for example, chemical formula, and you can patent part of it, which is there has to be a specific effect in the overlapping range. So this is rare. It's mostly in chemical patents. But, for example, there was a recent decision of the Technical Boards of Appeal where novelty was a double selection of parameters. So it was not chemistry, it was a different technical field. So it is there, but rare. But I wanted to be complete. So RADS, I always say RADS, the first letter of the four: replacement, addition, deletion, selection, that's novelty. Now we can continue. Of course, I mean, if we want to make things graphically represent it graphically, we need a graphical representation of inventive step. Now let's start from the left. On the left, I put closest prior art. So this is a definition which is in most decisions of the Technical Board of Appeal. The closest prior art would be the document with the most overlapping technical features, similar activity, and all that. I think that's quite clear that you will always, if you make a search and you find some documents, you will always try to find one document which is the closest prior art, and that is, it is reasonable to start from that document. It would make, for me, it wouldn't make sense to start from another document. But of course, if you are unhappy enough, you will find several documents which are respective closest prior art. There was a famous case, I think 2 or 3 years ago, when the technical boards stated there are 7 documents replacing each the closest prior art. So they said in such a case, it doesn't make sense to talk too much about inventive step. It's inventive, but okay. So this is not always easy, but let's take an easy case. We have a document where we can really identify the closest prior art. And then to the right, we have our invention, the claimed subject matter, the invention. You see, there's a novelty rendering technical feature, the same activity, no change. So what would happen if we would find a document, literature, patent document, whatsoever, in the prior art, which shows the same novelty rendering feature, but with a similar object, subject? That's what I put this M star, M2 star. That's similar patents or literature whatsoever, something in the prior art, maybe common general knowledge, but would reflect the same novelty rendering technical features. And you would know that. So I think it's logical, if you start from the closest prior art, you have the information that this novelty rendering technical feature, maintaining the same activity, you would immediately, without any reflection, without any effort, you would arrive at your invention. So this is a case graphically put down where inventive step cannot be recognized. And you can use that for each and everything. I'm going to show you some examples later, but this works for any possibility, for compounds, devices, for processes, so it's generally applicable. You see equivalents, analog synonyms that can be a lot same or similar technical fields. Again, M star, that's the preamble, and A is again activity, effect, property, result, purpose, function. So that's applicable to nearly every patent. So let's go on. If you remember, there is this second possibility that we want to improve something. And of course, if you compare the situation here, we start from the document of the closest prior art, and we find, by searching, or sometimes the prior art is mentioned in the description of a patent, that there is a document or literature or patent which shows you that this novelty rendering feature and this change in activity, effect, property, function is already described. Then, of course, if you have this information, you would not at all be surprised if this works also for your invention. It is no invention. If you have such a case, there is lack of inventive step. I show you concrete examples later. So this is the very general possibility of demonstrating inventive step graphically. So people who see this for the first time, I gave a lecture in industry, so one of the patent examiners, the examiners working there, he said, but that's inventive step visible. I said, yes, that's exactly, you can predict what kind of documents you want to find, you have to find in order to recognize. I mean, the situation is clear. If you don't find these documents, inventive step has to be recognized. It's just before you start the search, you could easily define what the situation will be at the end of the search. Either you find these documents, lacks inventive step. If you don't find them, one sentence, since a document showing with a note was not found, inventive step has to be recognized. So it's quite easy. The same for an opposition case, for example. If a patent was granted, then you can file an opposition. If you are if the patent doesn't like, and then you introduce a document that shows this situation, and before inventive step had been recognized, it's quite easy. It's a decision of 5 minutes. They say, no, there's no inventive step now with the new document. So this is very helpful, I think, in the system. Okay, next one. Yeah, that's the German Patent Act. What did I show you here? Well, I showed you graphical representation of the famous problem-solution approach without mentioning the wording. So that's when I was invited to go to Indonesia, I asked myself the question, what do I do in a country where this famous problem-solution approach doesn't exist? So I thought about it, and I found this presentation I showed you. This is until now a novelty inventive step. This is actually the problem-solution approach of the European Patent Office without mentioning problem and solution. You see, in the German Patent Act, we have this there is a technical problem mentioned and a solution for inventive step. But as I'm going to show you later, this problem is not the problem of the European Patent Office. There are differences. So the next slide, please. Yeah, in the Indonesian Patent Act, Article 7, the invention evolved if the said invention to person killed in the art constitutes to be non-obvious. You have this term obviousness. You don't have the problem, you don't have the solution. But as I'm going to show you later, this problem-solution approach is very helpful for this assessing inventive step, even if you, and I give you some reasons why. And you see here in the Indonesian Patent Act, inventive step is well, you have the term obviousness, which I think has the risk that it is more or less subjective. I can show you in other patent acts, not only in the Indonesian Patent Act, there is the same problem. Okay, next slide, please. Yeah, here you see the guidelines of the European Patent Office. An invention is considered as involving inventive step if having regard it's not obvious to persons skilled. Novelty and inventive step are different criteria. The question, is there inventive step, only arises if the invention is novel. I showed this because there was, not so long ago, there was the general opinion in some interested circles, some patent attorneys, even some patent examiners were of the opinion that inventive step is not so important. I think here you see in the guidelines, novelty and inventive step are different criteria and are important. And today the world is of course open to PCT, Patent Cooperation Treaty. You see the same in the PCT, distinct from novelty, more or less it's a different wording, but it's the same. Novelty and inventive step are both highly relevant for the patent. Next slide, please. Yeah, so we come now to the guidelines, this problem solution. What does that mean? And we have it clearly in the guidelines for examination. In order to assess inventive step, it is an objective and predictable manner. The so-called problem solution approach is applied. In the problem solution, when there are three main stages, determining the closest prior art. You remember to the left, I indicated closest prior art. That's the problem solution approach. Then establishing the objective technical problem to be solved. You remember these two problems, providing alternative further subject matter, the first, novelty rendering. Then the second, to provide subject matter with some unpredictable, unforeseeable activities, effects. So that's this objective technical problem to be solved. And then considering, that's the last step on the base, whether the so-claimed invention starting from the goal statute would have been obvious. And if there is this logical chain closed, I showed you for the two possibilities, then of course inventive step is lacking. So next slide, please. Yeah, you have the PCT in the PCT, Patent Cooperation Treaty, you have the same problem solution approach, the same steps. And yeah, I just wanted to show that what is done in the European Patent Office, in the EPC, is analogous in the PCT guidelines, and the European Patent Office is one of the, I think, 4 patent offices which are where you can file a PCT applications, having then protection in up to 150 countries. You just cross, and then there will be the international phase in the respective offices. European Patent Office, I think, US Patent Office, Japanese. There are 4 or 5 offices which are allowed to make this international phase. And then there's a first communication, written opinion, and a second. Then there is not a decision, but it's said whether what the examining division thinks about. And then it can go to the next phase, for example, the European phase or other phases. That's depending upon what the applicant wishes. But for big companies, of course, the PCT is the most interesting, and big companies file several thousand PCT applications every year. Next slide, please. Yeah, and now we come to the problem. Why is this so important? And I read an article a couple of weeks ago, and I used it also for the things I'm going to explain later, in which the problem solution was heavily criticized. And one of the points of criticism is that it is complicated, or it can be complicated, if you don't know actually what you want to find. And also and I'm going to refer to some other concepts for analyzing inventive step where you have exactly this problem. So what can you do to find what this actual problem underlying, objective problem underlying the application is? It should be an actual technical problem you will find in the patent application, actual technical problems in the field that can be put down, but is not necessary there. So you will find an artificial problem created by the applicant, a subjective problem. And well, you have to realize, is it really a patent-related technical problem, or is it something else? In descriptions, there is a lot of explication. Applicants tell you A, B, C to Z. So there's a lot of things described, which may be sort of technical problem, but which is completely irrelevant. So the main problem is the problem directly related to those is a parameter of the PSA. I showed you, providing a further alternative subject matter, or providing a subject matter with additional effects. So this is a parameter. And for example, you are allowed, this is very user-friendly, you are allowed to reformulate your problem. If you cannot solve one problem, you are allowed to go back or go up to a different problem. We'll see that later in decisions. So if it's not allowed that the problem you formulate contains pointers to the technical solution, sometimes you will find that. And what is also confusing, the problem does not have to be new. It can be the same in various. Some people say the problem has to be. No, it does not have to. It can be the same technical problem solved in a completely different manner. And the objective technical problem starting from the goal, that's what we want. But as you see, there are a lot of things which may guide you to a problem which is then not the objective problem we need for the problem solution approach. And when we come to the different patent laws and the different concepts for inventive step, we will see that this causes some problems. The problems cause problems. So the next slide, please. The process. Can we go to the process? Of course, I mean, until now I talked about physical entities, products, devices, but the same applies, of course, for physical activities. For example, a process. I mean, this example is very simple, but it shows you that it would work for any process you can have. Imagine a very simple process, steps A, B, C, and you would change the steps B and C, so the invention is A, C, B. Very simple. I mean, it's not very often so simple, but just to show that it works also for processes, then if you would find in the prior art for a similar process, this inversion of steps would be lacking inventive step. Of course, there are some conditions. The steps do not have to have a specific importance for the whole process, but just to show you that this, of course, works not only for physical products, physical entities, but also for physical activities, so for processes and so on. So that's the processes. And the next, I told you there's a lot of criticism, in particular when this problem solution approach was introduced in 1983 2003 in the European Patent Office, a lot of criticism came from Great Britain. British patent authority reacted very much to that, and their main criticism was hindsight. So hindsight, that's you are not allowed to use information from the patent or from the application to do something for inventive step. But this is, in my opinion, this is also the criticism in this article, which was published a couple of months ago in Grow International, criticizing very much the problem-solution approach in the EPO. The main point is this hindsight cannot be avoided. How do you want to judge, to assess novelty without reading completely the specification? It's impossible. How do you want to say something about the novelty running features? How do you want to say something about the different, is it something to provide further alternative thing or something? I mean, you have to read it completely. So this idea of not, and then you would, theoretically, the idea is you would have to forget it completely for inventive step. But this is, I mean, it's theory, it's nice, but in the end, it's impossible in my eyes. So I put this graphic a bit different so that you see now you need, of course, the prior art to identify the objective problem. Unless, how do you want to make the first two steps? You need the prior art. Otherwise, you cannot, you need at least a novelty rendering technical feature. Otherwise, if you don't know that, you cannot identify the closest prior art. And if you want to formulate the objective problem, you also have to know what kind of patent you want to produce. So this idea of avoiding hindsight is nice, but in my eyes, it's a theory. And insofar as problem-solution approach, for the first two steps, not for the third step, you don't need the information, but for the first two steps, you need to know the subject matter which is claimed. It is impossible to do that. And I'm going to show you in the patent system which use a different approach where the problem lies. So the next point, yeah. Now I promised you to show you concrete examples. For non-chemists, forget the chemical structures, but what you can see here is a decision of the technical boards of appeal. It concerns fungicidal compounds, and you have a replacement. To the left, that's a fungicide where you have a CH, the red structure, and in the claimed patent, the claimed subject matter, you have a nitrogen. So this is novelty rendering feature. And in the prior art, that was the problem, there was a very similar structure, but it differed. You remember MM star, so you have here the very concrete similarity, analog, equivalent, which differs by this group CHTH for both novelty rendering features. So you have the novelty rendering feature in a similar compound for the same activity, and there is no inventive step. The skilled person who is working in that technical field, who wants to provide a further fungicide with this different structure, and he finds exactly this structure, this novelty running feature in a similar compound, what would he expect? He would expect a fungicide and nothing else. But for chemists, it's obvious. I mean, any chemist would, without this a document, you would expect the novel compound to be a fungicide. And that's one of the main ideas. Also, problem solution approach was criticized as being non-technical. But at least for chemical inventions, this is wrong. It is what the chemist does. The problem solution approach is nothing else than applying empirical chemical rules. And so this is technical. This is really technical. In chemistry, there is no doubt. So let's go to the next. That's something, another decision of the Technical Boards of Appeal. Forget most of it. I'm going to use the essential points. It's a replacement case. You see F1, F2, there's a different solvent in a battery, a secondary battery. And in the prior art, there is described this difference in solvent, that's well known, but for different batteries. The batteries have different effects, and the change of solvents have different results. So the technical board said, for the skilled person, there is nothing in this site, a document showing that the replacement of the solvent has the same effects as it doesn't exist, so inventive step has to be recognized. Quite clear from this document. It's showing that this is the non-deriving technical feature, F1, F2, is, or F3 in this case, is lacking, so inventive step. Next point, next slide. You don't have that in the Indonesian Patent Act. In the European system we have it, and many patent acts have that. The second, medical use. So you can, it was industry wanted that a known compound, known, but for example, as analgesic, and someone finds out that it works as a anti-cancer agent. So industry, pharmaceutical industry wanted patents on that. The use of, here you have treatment of a compound, experimentally induced ulcer, and in the prior art, and the same compound is found treatment of gastritis resulting from inflammatory disease. So you have this novelty rendering function. You see, these possibilities are limiting, but it still works, but yeah, it works. So the problem in this case was, or what was negative for the applicant, in the prior art, there was found a document which combined these two pharmaceutical activities. So if you know that document, it is clearly, it is obvious that this activity is in the, if you know the activity of the closest prior art and you know this literature, you would expect this activity also. So you can show this with some limitations, but it is clear that's the problem solution approach. If you find a document relating, for example, the two medical uses, no inventive step. And the next slide, please. Now that's one of the famous cases when the European Patent Office started. That was, I think, one of the first cases where two big companies attacked each other in a problem. Famous Epi Lady case contained a hair shaving system for women, but that's not important what it is. It is a replacement case. But what I find interesting is here you see the opinion of the opposition division. There was a patent was granted, it was opposed. Then we have our proceedings. The parties are invited to present their observations, and then a decision is made. In this case, the opposition division came to the conclusion that this replacement in the shade was they considered the first problem to be a further alternative shave, And they said, this is not inventive. But then, let's take the second, the next slide, please. The board, there was an appeal against this decision, and the board came to a different conclusion. They said, no, the problem is not the provision of a further alternative shaven system, but it is a subject matter with improved unexpected effects. And they said, since this problem is solved, there is no inventive step. But the interesting thing is, the opposition division had there was a different problem underlying this for the whole case in comparison with the Technical Board of Appeal. But that was in the beginning of the European Patent Office. I think today there's much concern about, is the technical problem really solved? And I read this description and I have my doubts whether there are, well, they say improvement, but there is no improvement. I couldn't find it. So this is, of course, very important. The technical problem, so defined as objective technical problem, has to be solved. Otherwise, you can get any patent that you want. Next slide, please. Yeah, what I said, that's just another one for chemists. The problem-solution approach is exactly what the chemist does. There are empirical rules in chemistry, structure-activity relationships. Every chemist knows that. And problem-solution approach is exactly what the chemist does. He modifies the structure star. He has a novelty-rendering feature, and he, of course, because he knows structurally, he would expect the new compound to have the activity. This also can be applied. There are literature about structure property relationship, structure function relationship for some proteins, structure odor relationship, so you know there is a certain part of the molecule which is responsible for this odor, or what's the toxicity. So what should be searched, of course, in such a case, do such documents exist, and then there is no inventive step. But just this is very specifically for chemistry. But okay, next. Yeah, I promised you to compare this problem-solution approach to other patent acts, and I found this description of the highest German patent court, the German Federal Supreme Court, VGH. And there they have these 4 points for inventive step. Skilled person is determined. This is already a bit subjective, because what is the skilled person? You can have different opinions on that. Then the claim is interpreted from the skilled person's point of view on the effective date. It may also depend upon the knowledge of the persons involved. But then the objective solved problem is determined. That is again something which is quite similar to the problem-solution approach. And then something which is, in my eyes, again, a bit subjective. The starting point is determined. Obviousness is assessed there. If you interpret this in the sense that the logical chain is closed in that graphical representation, that's the same. Right? So let's go to the next patent law. Yeah, you see, yeah, that's the German patent involving inventive step, and that's again. You have this. I mean, the German Patent Office officially does not have the problem-solution approach, but if you look into the Patent Act, you will find this very, very similar. As I showed you, the objective problem is not absolutely identical, and the main difference is there is no relation to the novelty rendering subject matter. This technical problem is different. It looks like very similar, but it is not taken into account what renders something novel. But this is used, and this is very important for the problem solution approach. So one has to be very careful when one reads the patent acts. The wording here, you see, not obvious, a technical problem, assessing the objective you have. It looks very, very similar. And I talked to a colleague, I know him, he works as patent examiner in the German patent office some weeks ago, and I asked him, what about the problem solution? And he told me it's not, you can use it, it's not forbidden, but officially it's not, it's in that form, so it is not the objective technical problem is not referring to the novelty rendering technical features. So there may be differences. So let's go to the next. Now this is the US approach for non-obviousness, determining the scope and contents of the prior art. Okay, ascertaining the differences between the prior art and the claims art issue. Okay, novelty. Then resolving the level of only in the pertinent art. Yeah, what is that? Considering objective evidence, non-obviousness, obviousness. I think for me there is a lot of subjective things, because finally the person who decide that, they have a different education, a different formation, so there may be differences. No problem, no solution. And I heard that even one patent court in the United States said problem solution is forbidden. So that may be an exception, but problem solution is, in the States it is not applied, not at all. So the difference are clear. So the next system. Now we go to the United Kingdom. Construction of the extent of protection, determining the extent of a step. So the claim would be lack of novelty, determining the common general knowledge of the skilled addressee of the experiment. Yeah, novel common general knowledge, that's something which may be subjective, maybe not. Fourth step, determining whether such a person would have perceived such a step to be already effective evident to him and obvious as a matter of law. You have again this term obvious, which in my eyes makes it has always the risk that it is subjective. It depends upon the persons involved, and that's exactly this the problem that many people have with the inventive step. I mean, if you look into the literature, you will very often find the assessment novelty, that's clear, inventive step, that's impossible because it is subjective. But I hope that I could show to you that this problem solution approach is at least a possibility to be nearly objective. But then let's go to the next, what is in the United Kingdom, there is, I found an article which says that they now use a decision windsurfing test. So this, that is only some years old, there you have some similarities to the problem solution approach. Identify the notional person skilled. That's again difficult. Identify the relevant general knowledge. Again, identify the inventive concepts of the claim, and then identify what differences exist between the matter cited and the inventive concept, and then viewed without any knowledge of the invention. Nice theory, but in practice, I think more or less impossible, as claimed. Decide whether those differences, here you have the reference to the differences, to novelty, constitute steps which are the obvious to the person. So here we have an approach, approaching the problem solution approach with this, the last point, the differences, the novelty running technical features. This is going into the direction of the problem solution approach, but it's not the complete problem solution approach. Okay, the next one. Yeah, I want to come to some conclusions. I tried to convince you that this problem solution approach, which is more or less mandatory in the European Patent Office, I mean, there were some decisions of the Technical Board of Appeal in which they stated you are allowed, in some cases, it is possible to use a different concept. Okay, there is one famous decision in which they said this, so nevertheless it will be applied normally, and if you see, a colleague showed me what when you grant a patent, you have a default on your PC where you have to fill in novelty, so they have to fill in, the examining division has to show the novelty rendering feature is, so that's the first part of the problem solution approach. The closest prior art is, that's default when you grant a patent in the European Patent Office. The closest prior art is starting from this document, the objective technical problem is, and then this problem is solved according to data whatsoever. So it has to be verified with the so-defined problem. So in my eyes, this problem solution approach is really a possibility of a standardization independent from any personal knowledge. That's problem sometimes. It is reproducible. I mean, this graphic is, you can do that very quickly. Expert, quick, reliable, and it is nearly objective. I mean, the rest, which is not objective, is this, if you remember this MM star. How far do you want to search? This is depending upon the knowledge of the examiner or the examining division. I'm no expert in artificial intelligence, but should be very easy to make a program which would guarantee that in all technical fields the same level of search could be done. So that this could be, I think, for someone who is working in artificial intelligence, this last part of subjective influence could be pointed out. So nearly objective, and it's abstract. You see, it's really, you don't need to be an expert in these technical fields, because you can, these small graphics, it's absolutely for a lawyer, for someone who is not a scientist, he can understand that. And nearly objective, yeah, expert, I think this is really, if you apply that on a regular basis, it is clear and objective. And in chemistry, it is the problem solution approach is what the skilled person in the art does. And then general structural function, technical features, yeah, that's the, when I'm a chemist and when I started examination for a chemist, novelty is quite simple. You have a structure, a molecule. How do you make it novel? You replace one substituent by another, novel. You delete the substituent at a certain position. You add a substituent where no substituent was, and you can make this selection. So in chemistry, novelty is quite simple, and that's then my next idea was structural features are only specific technical features. So I'm just showing you how I developed this approach. I started from chemistry, for novelty of compounds, and then I went further to technical features. This structural are only specific technical features, and then you can apply it to in all fields. The only condition is that you can clearly define the novelty. But I showed you this in my first slides. And then you have a very, for me, if you explain to me what you want to invent or what you invented, it takes a couple of minutes, and I can tell you what you need to find as objecting inventive step, and I can clearly tell you, and you can too, if you apply that, whether there is a possibility of inventive step or not. And of course, you can see very quickly if it is a trivial patent or not. So I think that's the end. One more, some consequences. The inventive step can be made visible. And of course, I mean, the text is very well known. I showed you the text, but this graphical representation is replacing and supplementing the text. You have the abstraction, reproducible, striking, reliable, all these things that you actually want. Not forgetting that the technical problem is a parameter of the PSA. It can be reformulated. And the same clear incentive in the search which document have to be retrieved. It is strongly suggested in the European Patent Office. And what I found, when I worked in the office, as soon as you, in your first communication, you say the problem appears to be, this opens a dialogue with the applicant, because he will then say, no, the problem was, and they say, okay, is this problem solved? So this approach is also a very good possibility if you start the dialogue with the applicant. And again, this warning, trivial patents make it easy for patent trolls, and if you grant too many trivial patents, the patent system as such will lose its credibility. And the most important reason for granting patents for innovation cannot be met by patents which cost, and then they do not contribute to innovation, because there is more or less no inventive step. So I think we did it. Next slide. So thank you very much for your attention. What I tried to do in this lecture, I showed you that you can use the wording of the problem issues, a solution approach, that was the third part, for showing how you can assess novelty and inventive step. And this is actually, this graphical representation is nothing else than the wording of the problem solution approach. And then I showed you some connections between the different patent laws, and hope I could convince you that this problem solution approach is at least, I mean, what is perfect in this world? Very few things, but for me it has the most attractive points for the assessment of inventive step. Thank you very much. If there are questions, I will be happy to answer them. Thank you very much.
Thank you very much.